You know, sometimes the absolute biggest battles start in the quietest neighborhoods. And that's exactly what happened in Sun Lakes, Arizona. What seemed like a routine agenda item about a tennis court upgrade, well, it spiraled into a year-long legal fight, pitting one single homeowner against his entire homeowners association. And at the very heart of this whole thing was that homeowner, Anthony Horn. This quote, it just perfectly captures the frustration he felt. Here he was, trying to hold his HOA accountable, and somehow he's the one who ends up on the defensive. So let's break down who's who in this fight. On one side, you've got our petitioner, Anthony Horn. He's a resident, a member of the community's tennis club. And on the other side, the respondent, the Sun Lakes Homeowners Association #1. Basically the governing body for his entire neighborhood. All right, so here's our roadmap. We're going to walk through this whole case, from that first dispute over the tennis courts, all the way to the final judge's decision. We'll dig into the specific law at the center of the argument and see what this whole thing tells us about that classic tension between rules and community. Okay, so this whole story kicks off at an open board meeting back on July 6th, 2021. And you have to understand, the community's tennis courts were in really bad shape. So bad, in fact, they were considered dangerous, and they'd had to cancel tournaments. So when homeowners like Mr. Horn got the meeting agenda, this is what they saw. Motion number 3. Looks pretty straightforward, right? A much-needed upgrade and repair with a clear price tag. For a lot of residents, especially the tennis players, this was a huge relief. But then, in the middle of the meeting, the board president drops a bombshell. The upgrade and repair wasn't just fixing the courts, it also included converting one of the main tennis courts into 4 permanent pickleball courts. Now, that little detail, it was nowhere in the written agenda. For Mr. Horn and others, it just came completely out of left field. They felt like they had no time to prepare, no way to really understand what was happening. And you see, that feeling of being blindsided wasn't just a personal complaint. In Mr. Horn's mind, it was an actual violation of state law. And this gets us to the legal core of his entire case. It all boils down to this specific Arizona statute. It's part of the state's open meetings policy, which is all about transparency. The law basically says that agendas have to give homeowners enough information to know what's really going to be discussed and decided. The whole point is so you can show up and participate in a meaningful way. Mr. Horn's argument was simple. Tennis courts upgrade and repair did not reasonably inform him that a pickleball conversion was even on the table. Now, before this thing could even get to a full hearing, there was a pre-hearing conference to really define the scope of the dispute. And this is where the legal battlefield got a whole lot smaller for Mr. Horn. What's so interesting here is how the legal process just filters out a person's broader complaints. See, Mr. Horn wanted to talk about a lot of stuff. What he felt was discrimination against the tennis club, health and safety issues, a general lack of communication. But the judge shut all that down, ruling that his case was only about one single thing. Was the notice for that July 6th meeting proper or not? Everything else was completely off limits. And this really illustrates the personal cost of that narrow focus. The judge told him that if he wanted to argue about something else, like discrimination, that would be a separate issue, requiring its own $500 filing fee. On top of that, because of a delay, Mr. Horn had to shell out nearly $400 just to re-serve subpoenas. So this wasn't just a fight about principles. It came with a pretty steep price tag. Okay, let's get to the main event, the formal hearing on August 1st, 2022. After months of delays and procedural stuff, both sides finally got to make their case in front of the judge. The arguments were pretty clear-cut. Mr. Horn claimed the agenda was deliberately vague and violated his right to be properly informed. The HOA, on the other hand, argued that tennis courts upgrade and repair was a good enough description, and hey, even if it wasn't perfect, they fixed it later. And the HOA's attorney, Emily Mann, she did not pull any punches. Right in her opening statement, she framed the entire case not as a procedural issue, but as a personal vendetta. She basically argued that Mr. Horn was just sore that he lost the pickleball debate, so he filed this meritless petition as a way to punish the association. But this was the HOA's ace in the hole, their strongest defense. They argued that even if the July agenda was flawed, which they didn't admit, they legally cured it. Cure is a legal term for taking corrective action. So 4 months later, they held a second meeting with an agenda that explicitly mentioned the pickleball conversion. They voted again, and it passed. In their eyes, that second, totally proper vote made the whole complaint about the first meeting a moot point. So you've got 2 completely different versions of reality here. A homeowner who feels deceived, and an HOA that says it followed the rules and even fixed any possible mistake. So how did the judge see it? The administrative law judge, Velva Moses-Thompson, broke her decision down into two key parts. First, she decided that the original notice was legally sufficient. She said the HOA was not required to specify the method of upgrade. But then she delivered the second blow. She ruled that even if the first notice hadn't been good enough, the HOA cured that problem with the second, more specific meeting in November. And with that, the case was over. The judge's final word was crystal clear. Citing that two-part logic, she ordered that Anthony Horn's petition be dismissed. The HOA had won. So the legal case might be closed, but this story really shines a light on that deeper tension you see in so many communities, that tug-of-war between just following the letter of the law and actually fostering genuine, transparent communication. You know, during his final rebuttal, Mr. Horn laid out this catch-22 he felt trapped in. He argued that the only reason that second, more specific meeting even happened was because he filed his dispute in the first place. So from his point of view, the HOA makes a mistake, he spent his own money to call them on it, and all they have to do is hold a do-over, which cancels out his complaint and leaves him out $500. As he put it, that ain't fair. And ultimately, this whole case leaves us with a really fascinating question. Legally, the HOA was able to cure its potential error. But does a procedural fix like that actually repair the breakdown in trust that started the whole thing? It really makes you think about where the line is between what is legally good enough and what is truly open and fair communication within a community.